is the reason. It's not just that I am imagining people who might not be on the call. We always have room for public comment at the end of each of these meetings. If you happen to tune in or are a member of the public, we just ask that you drop myself or Carrie Steele a note in the chat to let us know that you'd like to address the public. Other than that, just some group norms, as we always do. We ask members of the subcommittee, if you're in a place where it's safe and comfortable to do so, to turn your camera on. Cindy does not include you since you're in transit, so stay safe. Everyone else, as you introduce you or as you come on camera to speak, we do ask that you introduce yourself by name for anyone watching or listening through any of the streaming means. And finally, we ask everyone to avoid using the chat. It can be distracting for all members, and it can be particularly distracting for anyone using a screen reader or other adaptive technologies. If you've got an urgent issue, by all means, drop myself or Carrie a note in the chat, but otherwise we try to avoid the use of that. With that, I'm going to quickly cover what we're going to go into today, and then I want to introduce our guest panelist. And what I'll do is ask Spencer a few questions, and then I want to open it up to a pretty casual conversation with the group. Our goals today are, number one, to hear from Spencer, who I'll introduce in just a minute. And then we're really going to shift our gear to the conversations this summer. This will kind of be our pivot point meeting. And as we start getting together in June and through July, August, and into September, our conversations are going to be about developing possible recommendations. And I emphasize the use of the word possible because our current intention is that at each meeting, we will go deep into one topic. For example, we may spend one meeting talking about emotional distress damages. We may spend one meeting talking about caps or adjusting limits and dollars. Then what we want to do is take a handful of ideas that you all surface as possible solutions and really socialize and stakehold those. So we'll spend the meeting digging deep into what the possible ideas are. We're not going to introduce them to the public as, hey, here's our recommendations. It will really be framed more as, here's 3 or 4 ideas we're considering. What do we need to know based on your lived experience, your professional experience, and other types of perspectives on that? And then we'll bring that back to the following meeting. But with that, what I want to do is shift. We've heard from a number of folks about some of the challenges in whether it's litigation or the administrative process. We know some of the challenges from all of your experience and expertise in folks bringing cases forward. We have an opportunity to hear from a really smart and experienced guest who has been both a claimant and has represented others. So Spencer, I'm going to ask you to introduce yourself and where you come into this conversation. And then I'm going to ask you a few questions, both about your experience with that jury selection, so folks can hear directly from you. And then we want to have a conversation with you about what it's like for a for-profit attorney to have to decide what cases to consider and what some of those considerations are. But with that, Spencer, number one, thank you very much for making time to join us. As we know, you just shared you're doing preparations to get in front of the 10th Circuit, so we'll be efficient with time. But would love for the members that don't yet know you to hear your background and where you come into this conversation.
For sure. Well, thank you everyone for having me. It's a great opportunity to be able to chat with you about some amendments to the Colorado Anti-Discrimination Act. I'm very passionate about this, both personally and as an attorney, being this is my practice area. So I'm a civil rights attorney here in Denver, Colorado. I am deaf in my left ear, and I have a profound hearing loss in my right ear. To be honest, for the longest time, I kind of tried to keep an arm's distance from anything disability rights related because I didn't want people to sort of associate me with being disabled or less capable than maybe other practicing attorneys. But once I graduated from law school, I had the opportunity to work on a civil rights case where I was actually at a big firm and I was a defendant in the case, representing a defendant in the case. And we managed to win the case, which was good at the time, but I realized at that time that I really had a calling and a passion for wanting to work with individuals with disabilities to ensure that I was able to provide representation to them and allow them to have equal access, whether it be in an employment context or a public accommodation context. So I think I can tell you a little bit about my personal experience, and then I can also tell you a little bit about my experience as an advocate for individuals with disabilities. Personally, I was served with a notice for jury summons. I believe it was 2 summons ago, maybe 3 summons ago. And I showed up for jury service, and I had requested a CART interpreter. That's a communication access real time. It's essentially captions that show up and real-time captions of all of the proceedings. And when I showed up for jury service, the CART interpreter was there. And I walked up to the point where you're about to walk into the courtroom. So I never went into the courtroom. And the CART interpreter went inside and set up the services, which would allow me to have CART interpreting services real time. And the judge, the DA, and the PD, they elected to just dismiss me from jury service. And so the CART interpreter walked back out of the courtroom. Again, I never met any of the judges or the juries or any of the judges or the attorneys. And the CART interpreter told me that I had been dismissed and I could leave. And, I had to walk out in front of 20 to 30 other individuals who had all taken time out of their day to appear for jury service, which is something that I take very seriously given, what I do, and something that I was actually excited to be able to participate in. And I had to walk out of there, and it was embarrassing, and frustrating. I've worked very hard to put myself in a position where, I can appear in court on behalf of clients. I try cases in front of judges and juries for clients. And, I was kind of viewed as someone who was disposable just because I had a disability. And that was really frustrating for me because what ended up happening is we pursued a lawsuit. Well, we tried to settle the case first. We weren't able to settle, but we ended up pursuing a lawsuit, and the court essentially determined that there was no remedy. The court determined that there was discrimination, and the court held that there was likely discrimination, but there really is no remedy for an individual in that situation. I could not recover attorney's fees. I could not get an injunction. I could not recover any sort of statutory fine. And I think that was just really difficult for me to accept because, if somebody's discriminated against based on their gender or their race or their religion in a public accommodation context, there's a remedy there for that. And so that kind of brings me full cycle to where I am as an advocate. So when I set up my firm 7 years ago, one of the things that I really emphasized was taking on disability discrimination cases, both in an employment context and in a public accommodation context. And one of the cases that was sort of the foundation for my practice from 2016, 17, when I set up the firm, until 2022 was the case Cummings versus Premier Rehab. And that case essentially, prior to Cummings, the rule of law, more or less throughout the country, was that you could recover uncapped compensatory damages for intentional acts of discrimination. And the Supreme Court in Cummings essentially said, it didn't say that those types of damages should not be available in these cases. It said that those types of damages are really more up to the states to decide, because the issue of Section 504 is an issue of a contract between the federal government and the state. And so what happened there is the court sort of said, you can't foresee compensatory damages in a contract case between the state and the federal government. And so what they kind of did is put the onus back on the state legislators to determine what are the remedies for someone who is disabled and is subject to discrimination. And, I think that's where Colorado and, this group has an awesome opportunity to sort of fill in that blank. Because right now, if I have a client who comes to me and they're kicked out of King Supers because of their race, they have an actionable claim where they can potentially recover punitive damages, uncapped punitive damages, emotional pain and suffering. They can recover basically whatever type of damages that are available. If I have a client who comes to me and says, I was kicked out of King Supers or a public accommodation place because I'm deaf or because of my disability, the ability to pursue that type of case is next to impossible. And for the most part, as a private practicing attorney, I have stopped taking those cases. I try to take some every now and then just because it is something that I am passionate about and it is something that I care about. But with the Supreme Court's ruling in Cummings and with sort of an absence that wasn't needed until after Cummings in Colorado state law, it's really difficult to pursue any type of claim in Colorado. We don't really have the ability to recover anything more than a nominal statutory fine. And there really isn't an avenue to make that a feasible practice for a private practitioner, which means that nonprofits, the Colorado Cross Disability Coalition and a few other nonprofits, they have the basically burden of trying to take on the vast majority of these cases. And it happens a lot more than you guys would probably think. And so a lot of people just end up with no remedy and no representation. I think it's something that I personally struggle with, both as a claimant trying to pursue something like this. I was fortunate to be able to have the connections and means to even be able to pursue it in the first place, but ultimately the court said no, there's no remedy. And then as an attorney, having clients come to my office say, hey, look, here's what happened, and I'm having a very viable claim. There's just no way for me to make it financially feasible. That becomes a real problem, and it allows discrimination to sort of go unchecked. And I think, it's really great that the committee is sitting here sort of assessing, what are the next steps. And I have a lot of thoughts on that. But I might let you kind of like jump in and ask some questions. I'm happy to just keep going if you want.
Now, one, thank you for that background. What I want to do is a few things. I want to try to separate out what I know is this intermingled reality of the case you experienced, the implications of Cummings, and the considerations for a private practice like yourself. I also want to make sure the folks that are sitting here on this call. We have a couple of lawyers, and I think a handful of folks. We also have people that aren't lawyers. And so a number of the members here are looking at this from a real practical, pragmatic, trying to understand some of the nuance. So what I'd like to do is go around this group first and just have everyone do kind of a 30-second lightning round of who you are and where you're coming into this conversation, so Spencer understands it. And then Spencer, I'm going to ask you just a couple of questions about this dynamic and the perfect example you gave of who can get kicked out and seek damages and who can't, and open it up to the group. Cindy, if you're in a place where you can, I'd love for you to introduce yourself, and then I'll go to Tom Aker.
So thank you. It took just a moment there. Can you hear me okay?
We can. Thank you, Cindy.
Perfect. Yeah, this is Cindy Vaughn, and I'm an individual who is deafblind. And I work extensively right now doing advocacy for individuals who are deafblind, have other physical, primarily sensory disabilities. And I've worked also extensively in the field with folks who have intellectual and developmental disabilities.
Thank you, Cindy. Let's go to Tom and then Alana.
I'm Tom Aker. I'm a representative of local government, and I'm also disabled. And I come
Alana and
from,
Laura. I'm sorry, go
pardon?
ahead, Tom.
I say I'm coming from more of how can local government better enforce some of the rules and regulations.
Thanks, Tom. Let's go to Alana and then Lauren, followed by Ian and Andrew.
Thanks. This is Alana. Yeah, I'm here representing business interests and yeah.
Hi, Spencer. Thanks for being here. It's Lauren Schwartz, and I'm work for the Colorado Chamber of Commerce. And so obviously I'm here to represent business interests. I'm not a lawyer and I'm not a lobbyist, but I would say the Colorado Chamber works heavily in the policy area. That's really our reason for being, is to advocate policies that will help Colorado stay competitive.
Hi, Spencer, Ian Kalmanowitz. Also, thank you for being here and telling your story. I really appreciate it. I am a plaintiff's employment lawyer in Colorado Springs. I represent people with disabilities in employment discrimination cases. I handle cases against the government and against private businesses. And I'm interested in hearing some of the ideas you have for how to deal with the post-Cummings problems that we're all dealing with now.
Hi, Spencer. This is Andrew Montoya. I think we've met a time or two before. I'm an attorney with the Colorado Cross Disability Coalition. Been doing so for about 15 years now, and pleasure to have you here today, and pleasure being on this committee.
Thank you all. Spencer, I'm going to ask one pretty broad question and invite you to go wherever you'd like with it. And members, let's keep this a casual conversation. Use the emoticon thing to raise your hand. Or if it's not handy, *6 will get you off mute and just join in. Spencer, we've been tasked with looking at this broad charge of how should COTA be rewritten to ensure the rights of Coloradans with disabilities. We've had conversations about what happens when the ADA changes, and we've got law that just references it. We've talked about the Cummings decision. This group has identified a number of definitions we need to probably codify into Colorado law. We're looking at things like caps on damages. We're looking at emotional distress and other compensatory damages. We've had conversations about damages being set based on the employer head count and whether that's the right idea, or should we be looking more at the revenue size of that business. But given your expertise and your lived experience, when you look at both the 30, now almost 40-year-old ADA, when you look at what happened with the Cummings decision, what are the ideas that you think this group should be considering as we look at making recommendations over the next 6 months to strengthen Colorado's Anti-Discrimination Act and do so in a way that we can build common ground and common understanding of the why behind that?
Yeah, so I've got a bunch of ideas. Dangerous to give me an open-ended question. I think it's a complicated process, and you guys have a tough mandate. But I think there are a lot of things that we or that this group can do to simplify COTA, but also maybe expand on it and make it more effective. One of the challenges is that COTA encompasses everything. You've got, part 4, 5, 6, 7, 8. You've got different remedies that are available under part 6, for example, which is public accommodation, and part 8, which is disability discrimination. And you've got different procedures that you have to go through when you have to go through like the employment discrimination context of filing a charge of discrimination versus the public accommodation context. So it's a very well designed statute to, prohibit and eliminate and provide remedies for discrimination in different contexts, but it's very broad and far reaching, and it's confusing at times. I think even in some of the cases that I've had in front of judges, federal judges even, who are interpreting CADA, they have challenges kind of figuring out, okay, like what does CADA exactly mean here? And so I think one of the big things would be really streamlining it a little bit in terms of, you know, establishing what remedies are available under each specific provision of CADA. Like, for example, the employment provision just adopting Title VII remedies, which is, you know, the damages caps. Or under Part 6, which would be public accommodation, you know, in Part 8, disability discrimination, adopting a more streamlined framework in terms of the damages that are available. I think one of the big things with the Cummings decision, and one of the big things that really need to be addressed in CADA, is figuring out how to assess the right level of damages based on violations that may occur. My sense is that the framework for all of you all is already there. The 10th Circuit, and it's a case called Barber. I'm sure Andrew and Ian know the case, Barber and Rebarber. It really already establishes the framework for determining the different levels of damages that would be available. Under CADA right now, and I think this is appropriate, you have essentially a statutory fine, attorney's fees, and injunctive relief, which is available to an individual who has been subject to discrimination for unintentional discrimination. Then, and at least the way it used to work in federal law, is if you can establish that a violation was intentional, meaning that the entity knew that what they were doing would likely lead to a violation or discrimination of established policies, and they failed to do anything to eradicate that discrimination or to eradicate the likelihood that there would be discrimination, then that individual could recover uncapped compensatory damages. I think in the context of creating a framework for damages, a damages kind of scenario under CADA, the commission really ought to just establish sort of a tiered system for damages that already sort of existed under the framework pre-Cummings, and that would be, you know, having sort of a baseline if you're discriminated against, having the ability for that individual to recover attorney's fees. Without attorney's fees, none of these suits are ever going to go forward. Having the ability to recover injunctive relief, that is critically important because that's how you prevent the discrimination from happening again. And then having some sort of, you know, statutory fine or capped level of damages for unintentional acts of discrimination. And I think this is important both because from the business interests, like, you know, Lauren, if you're talking to members of the Chamber of Commerce, you want to be able to tell them, look, like, if you do something and you make a mistake, for example, you didn't know that code interpreting is available, right? And some small business owners may not know that. You know, you're not going to be on the hook for a significant level of damages. You're going to have a small statutory fine that is not going to cripple your business. Now, if it's a situation where the business owner, maybe they were sued for it once before, or they knew the individual sent them an email saying, hey, look, here's what CADA says. Here's the resources that are available to you, and the business owner just sort of said, I don't care, and didn't do anything, then there's a second kind of level of damages that are available in the context of, like, you knew what you were doing was wrong, and you persisted with that course of conduct anyways. And so I think that really is the structure that should be followed. I think that structure already exists, so you don't have to recreate the wheel there. You can essentially, you know, take the language from that already existed and that still is there in terms of the case law in the 10th Circuit, and you can use that structure and establish what types of statutory caps would be appropriate, whether it's a one-time violation and it wasn't intentional, maybe the cap of $5,000 or whatever the cap is, that would be up for you all to decide. But then if there's an intentional violation, to really authorize a second category of damages, which would be emotional pain and suffering, or really even potentially punitive damages if there's multiple violations or something along those lines. I think that would be the single biggest change that is needed in terms of addressing CATA. And then I think really kind of establishing a more streamlined framework in terms of how the cases will proceed, whether it's under Part 8 or Part 6, so that there's more of a streamlined process. I think that's critically important as well. That would be that.
I'm going to jump in here only to allow all of the members to lean in, because I think that was some great thinking for us. Who has questions for Spencer about the framework he's suggesting, or about any of the bigger issues that were surfaced in his describing his experience with the jury duty, or his experience as an attorney having to decide what cases to take or not?
This is Lauren. I have a question, Spencer, and it's mostly clarification on the last point that you made. With some of your recommendations, you were talking, I just wanted to make sure I heard correctly. Did you say streamline the process as one of your last recommendations?
Yeah, I mean, I think really having a more streamlined process, or really just kind of more defined process. Streamlined may not be the right word. In terms of assessing damages and when they are available. The way it had been pre-Cummins, which, I think was very helpful for litigants, was having kind of a two-tiered system of damages, which is the baseline with attorney's fees and injunctive relief. That's available for discrimination, irrespective of sort of the malice or the level of culpability of the defendant, right? And then having a second category of damages, which is a heightened category of damages that is available when a defendant is, in fact, culpable for their conduct. So I think having that in the statutory framework is very important. And I think sort of explaining, like, here's what categories of damages are available, and here's when they become available and why they're available, it's going to provide a lot of guidance for litigants and a lot of certainty on both sides of the aisle, both for individuals like myself who represent individuals with disabilities, but also for businesses, because what you don't want to have is a situation where the court is just ultimately going to sort of make its determination about what types of damages would be available, because CATA already incorporates the ADA, it incorporates Section 504, it incorporates such a vast kind of law that exists out there, 40 years of jurisprudence that, like, is not always the same, right? Some circuits are treating it a little bit differently. So if we have, more established or defined process in terms of, like, here's how you get damages for a violation, here are the additional damages that are available for an intentional violation, and then perhaps here are punitive damages, which are available if you can establish malice or something along those lines. It makes it very easy for litigants and both sides, plaintiffs and defendants, to assess, okay, what are the merits of this case? What are the damages that are available? And that should hopefully provide the remedies that are currently lacking post-Cummins, and also provide certainty for the parties, which may be able to reduce attorney's fees and kind of help parties on both sides of the aisle be like, all right, we know what needs to get done to remedy the discrimination in this case.
Thank you.
Thank you,
So
Spencer.
one other thing that I wanted to add, and this is just solely in the context of employment. In Colorado, there is basically an open question about whether or not an employee can be terminated based on a prescription that they have for a disability for medical cannabis. So there was it's the Coates case, it's a Supreme Court case in Colorado that essentially said that you cannot consume medical cannabis under Colorado's legal off-duty statute. It did not address whether you can consume medical cannabis as a prescription for a disability, and whether that can be a basis for an adverse employment action. Other states, like New Jersey, New York, there's probably a few others, have codified this and specifically outlined that employers cannot discriminate against employees based on a medical cannabis prescription. There is not a case in Colorado that addresses this. I can tell you, my firm is going to be filing a lawsuit that is going to sort of address this issue, and it's an open question. So one of two things is going to happen. Either the court is going to make up a decision that they think is right, or this commission can establish a rule that they think is right. You know, my sense is that Colorado has been, you know, the constituents have decided that, you know, marijuana is not something that they agree with in terms of the federal government's classification of marijuana. And to the extent that, you know, you sort of take that idea that the constituents have established here, my sense is that marijuana should not, medical cannabis, and this isn't just recreational consumption, this is medical cannabis. An individual's consumption of medical cannabis off duty, so not, you can't get high and, you know, go to work or something, but that should not be a basis by which employers can discriminate and potentially terminate employees. There is already, again, legislation out there that Colorado can follow. We don't need to recreate the wheel here. Other jurisdictions have sort of already done the work for us. And there's other case law out there that, you know, I'm happy to send to Barrick or anyone else so that you guys can review. But I think it is something that the commission should address, because if the commission doesn't address it, then it's going to be up to a couple of judges. And I think this is really something that, you know, constituents who voted on this issue would be better positioned to provide their input and the rule of law here in Colorado versus, you know, a couple of appellate court judges.
Thank you, Spencer. And you're not the first one to have raised it, but I appreciate you walking us through some of the nuance and your thinking behind that. Members, I know Spencer has given us an awful lot, but I want to make sure each of you has an opportunity to react to ask him questions, both on the law side and the experience side. Alana, jump in, please.
Thanks. Yeah, this is Alana, and apologies if you've already answered this, but I just wanted to kind of confirm what you were saying about kind of reinstating the approach for the levels of damages for capped versus uncapped. Does that resolve kind of that category of cases you'd been talking about earlier that just are valid cases but aren't financially feasible to take?
Yes, it does. So, you know, the example that I kind of gave at the beginning, and, you know, I'll just sort of reiterate again, is right now, if someone walks into my office and they are kicked out of a place of public accommodation because of their race, I have a viable path forward as a private litigant to represent that individual. We can recover damages, emotional pain and suffering. We can recover punitive damages in some cases. Those cases at times can be quite substantial. If someone walks in my office right now and they are kicked out or discriminated against in a place of public accommodation based on their disability, the unfortunate reality is that I am turning away the vast majority of those cases. They are just not financially feasible for a private litigant to take on under the current framework of the law. So, I think that if there's one thing that needs to be adjusted, it really is that. Because there needs to be a path forward for an attorney like myself to say, hey, I'm going to take on these cases. And without that path forward, you're just seeing a lot of individuals with disabilities being left behind. I mean, the financial reality of running a law firm is that I have a business, and so when there's someone who comes to me with a race discrimination or a pregnancy discrimination or a gender discrimination, those cases provide a viable path forward, whereas the disability discrimination cases they're challenging. And to be clear, a part of that is not necessarily just an issue with CATA. It has to do with remedies that are currently available under federal law. So, for example, a race discrimination case is going to be a 1983 claim, and that is a remedy that I could pursue under federal. If 1983 didn't exist, we would have some serious issues with race discrimination cases under the current framework of CATA as it exists right now. But because that 1983 statute sort of covers those claims, it exists, but it is a shortcoming there as well. With the Cummings decision, that took away the ability to pursue under federal, the types of claims that you can pursue for race discrimination. So it's something that the committee maybe ought to keep in mind too when they're drafting it. I think Cummings really was a huge loss for the disability rights community, but it's also a loss for, women, any minorities, it's really, there just happens to be federal law that protects a lot of those minorities in a way that it does not protect individuals with disabilities.
Awesome, thank you.
Spencer, I know that we had asked you to stick around till about now. Can I keep you for about another 5 minutes for just a few more questions?
I can hang out for as long as you need.
Thank you, Spencer. Let me go to Andrew and then Ian then.
All right, thank you, Barrick. This is Andrew Montoya. Spencer, I just had a couple of questions for you. When you're talking about the cases you're not taking because they're not financially feasible, what is it about the current system that's making it not financially feasible? Is it the lack of damages, the ability to recover fees, the difficulties obtaining injunctive relief? What is it that makes it financially not feasible?
Yeah, I mean, I think the biggest thing is the lack of damages. So a lot of, for those of you in the group who are not attorneys, a lot of times private practice attorneys, when a client can't pay for a case, the attorney will take it on what is called a contingent fee basis. I'm sure you guys are familiar with that, meaning that they only take a portion of what is recovered, and the client essentially is getting a portion out of the final recovery, right? And when the only damages are a nominal statutory fine or maybe attorney's fees, it makes it almost impossible to take on a case like that or multiple cases like that, because you're essentially having to devalue all of the time that the attorney puts into the case to get it to a final resolution, or your client basically has to go through litigation without any sort of compensation whatsoever that's going to be contemplated. So it's a very difficult proposition for someone who, maybe they were discriminated against by a local government and they have to face down the idea of filing a lawsuit where the Colorado Attorney General is going to be representing the defendant and there's no financial gain whatsoever for them. And the attorney is going to tell them, look, like, I can maybe do this on a contingent fee, but you're going to have to pay for costs. So the client is going to have to pay for depositions. The client is going to have to pay for filing fees. If there's an expert that's needed, the client is going to have to pay for that. And like, that can be tens of thousands of dollars. And it's just economically not feasible for my firm to say, I'm going to take out tens of thousands of dollars in costs to pursue this case when the only thing that I might be able to recover is my fees and maybe those costs in the end of the case. So it's just, without having some damages, that are recoverable, and without having that sort of tiered category of damages, it's just a situation where a private firm, maybe you can take one or two of them, maybe, but you just can't pursue those cases on a regular basis because it's just not financially possible.
All right, great. And then, kind of a couple, I guess a two-part question here. On that kind of first level of, the statutory fine, unintentional discrimination, what are your thoughts on the current $3,500 amount? And then secondly, with respect to intentional discrimination, I can tell you in our experience doing these kinds of cases, we've pressed the intentional discrimination claims before, and courts have always gone the other way. We've not actually gotten to court to find intentional discrimination, even though it's the standard that exists and doesn't require that you have discriminatory intent in your heart. It's like you said, you're pursuing something that is likely to lead to discrimination. So I mean, the second part is, have you in your practice had courts find intentional discrimination in public accommodation or public entity cases?
So to answer the second part of your question, the answer is no. I think you can certainly pursue intentional discrimination cases, and there may be situations where you're able to get, the parties to a settlement. But proving intentional discrimination and trying a case for intentional discrimination, even if emotional pain and suffering damages are permitted, is still a very difficult proposition for a private practitioner. Again, in an intentional discrimination case, let's say you even prove intentional discrimination, you still have to prove damages. So, if you have a situation where you're talking about, let's say, a local mom and pop coffee shop, and somebody says, we're not going to serve you because, you're deaf or because you're disabled or whatever the disability may be, what is the jury going to award for not being able to buy your coffee one? That's still a difficult case to take on because the damages, I think sometimes people think about like the McDonald's case or something, and people getting, these enormous jury award verdicts, like that just is not really consistent with the reality of what those verdicts are. So there was actually a very recent case in Nevada where a deaf individual was subject to discrimination and not provided an ASL interpreter, and the individual had broken hands. So the individual had to sign with broken hands because there were no interpreters provided, and the damages in that case, setting aside attorney's fees, were 50 grand. So it's not, that's a pretty egregious violation where someone's being forced to go through physical pain, and this was in a medical context, like physical pain and suffering to just be able to communicate, and the damages are 50,000. So it's, I think that just sheds a little context in the type of like, even when you have an intentional discrimination case, the challenges of pursuing that case are still very prevalent.
Thank you. And if I could just kind of redirect back to the initial earlier part of the question, what are your thoughts on the $3,500 current statutory fine?
Yeah, so, my sense is that that's not enough. You know, I think in terms of assessing like a statutory fine or in terms of assessing damages, my sense is that if it's an unintentional discrimination situation, rather than having like a streamlined statutory fine, there should be a cap saying like if it's unintentional, like we have not proven intentional discrimination, whether it's adopting Title VII damages cap, which is based on the number of employers, or however it may be, having some sort of cap on damages, because the problem is too, is like if you do a statutory fine of $3,500, that's going to disproportionately affect small businesses over large businesses, right? So I think there needs to be a scale that allows a jury or a judge, if the case is being tried before a judge, to assess, the level of damages that that individual has experienced. In terms of the cap, if it's going to be based on the size of the employer, I think Title VII provides you with the framework for a damages cap. Then if it's intentional discrimination, I personally don't think there really should be a cap. I think really the bigger question is if there's intentional discrimination and there's an element of malice or ill will, should punitive damages be available? And I think that's where, if you're talking about, oh my gosh, it's going to be a huge verdict, I think that's really where you're more likely to see it. It's more in a punishment context versus, what is the emotional pain and suffering. So I would recommend for unintentional discrimination, you follow the framework that, is already established under federal law, under Title VII for employment discrimination cases.
All right, I've got plenty more questions, but I'm going to go ahead and stop there. Thank you very much, Spencer.
Thank you, Andrew. And time allowing, we'll get back to you. Let me go to Ian and then Cindy.
Thanks, Barrick. Ian Kalmanowitz. Spencer, I have two questions. One follows, they both follow things you said. One follows your comments just recently to Andrew about the damage award style. And $3,500 as a fine is not enough, or a $50,000 damages award that you gave the example from the Nevada case where the individual had to sign with broken hands. Can you talk to why those numbers aren't enough?
So I think there's two components here. I think I've spent a lot of this meeting talking about the business reality component of it. And, I think that is one component of it. I think that's an important factor to consider in terms of assessing the viability for a practitioner to bring these claims, because if a private practitioner is not going to bring them, then the law is the law in name only. It's not going to be enforced. And the individuals who are protected by CATA are going to be at a huge loss. I think really the second thing is that assessing the level of damages and determining what happened in each individual case is fundamentally something that we as a country have always left to the jury to decide. No two cases are the same. And whether it be in the context of a car accident and emotional pain and suffering that that occurred from a car accident, whether it be because of sexual harassment in the workplace, whether it be because of an assault, whether it be because of race discrimination under 1983, really pretty much every area of law right now permits a jury to understand and assess the damages that an individual faced. The problem with having such a limited amount of non-economic damages available in discrimination cases is that oftentimes the only damage that someone experiences in a discrimination case is emotional pain and suffering. The vast majority of time, when I have a client come into my office and they've been discriminated against by a public entity, or they've been embarrassed and publicly humiliated, or they've been shot down time and time and time again by a bank and not provided with accommodations, there's no physical injury. There's no medical bills. There may be some counseling bills or, something like that for PTSD or, some therapy bills that they're going to have to pay. But there's no, the injury is emotional. That's the only injury that they suffer. And so capping that and having a low cap on that, it prevents the individual from being able to have their day in court and have a jury decide these are the damages that you experience as a result of that discrimination.
Great. Well said. Thank you. The second question is related to something that you had said about the Cummings case. And you touched very briefly on how Cummings had an impact outside of just the disability context in the law. And while our committee is focused on fixing CADA to enhance the rights of individuals with disabilities, any changes to CADA that we may propose, like for caps, for example, or changing penalties, are going to impact individuals with other protected statuses, not just disability. And so I was hoping that you could talk a little bit about Cummings' impact outside of the scope of the disability context, and also just in general, where these statutes that Cummings impacted are used. So for example, 504 isn't just something that gets used for purposes of places of public accommodation that receive federal funds, but also schools, universities, Title IX, Title VI, et cetera.
Yeah, so the impact of Cummings is honestly still to be determined. It has already had a far-reaching impact, and I will answer that question to the best that I can, Ian, but there's probably additional categories of lawsuits that it's affecting that I don't even know. Cummings was basically decided on principle that the federal government and state government enter into a contract, and emotional pain and suffering damages are not available in breach of contract cases. So that means that any state that receives, or any entity that receives federal financial assistance, is not on the hook for compensatory damages, irrespective of the type of claim. So there's Section 504. Well, so no, sorry, it is under Section 504 of the Rehabilitation Act, but that affects businesses that receive federal financial assistance, that affects universities. So Cummings has been used to prevent individuals in university Title IX cases from recovering emotional pain and suffering cases. It is also being applied in some cases to the ADA itself, because the amendments to the ADA, the most recent amendments to the ADA, adopt the damages framework from Section 504. So you could see, I mean, we'll have to see how far it goes, but I mean, Title II, which is public accommodation, Title III, local government. I mean, there's all of these parts of the ADA that are potentially under attack. Title IX, which had to do with gender, religion. There's a whole area of, really a whole area of damages that are now kind of on weak ground. And that sort of goes back to what I was saying about, CADA does protect individuals based on their race, gender, national orientation, and the other protected character traits. In my practice, I've seen it have the most effect in the disability context, because there are some federal laws that protect people for, gender, race, religion, national orientation. There are some federal laws that protect you there, but that is not necessarily a given. And so I think it is important when CATA is being rewritten to understand that, okay, we need to protect these remedies in the context of disability discrimination, but Cummings is gradually being implemented throughout the country, and its effect is still sort of being litigated throughout the courts, and it's going to have a large effect on a whole area of case law that is still to be determined a little bit. But yeah, I mean, I think to answer your question, Ian, the opportunity here to sort of make sure that the Cummings decision does not impact the remedies that have sort of always been available is there by making sure that, for example, Part 6 also permits the same type of remedies, and Part 6 is public accommodation, permits the same type of remedies that Part 8 does, which is disability discrimination. And that means that you're protecting people based on their gender, race, national orientation, religion, whatever it may be, sexual orientation, and providing those same types of remedies, because it shouldn't matter. If you're discriminated against based on your age or your sexual orientation or your religion, if you're discriminated against on that basis, you should have these remedies that exist. And so I think that's an opportunity for the commission in terms of streamlining it and kind of, simplifying it a little bit. That's one of the areas where it gets a little bit confusing, but making sure that those remedies are available for any of those protected classes.
Thanks.
Thank you both. Cindy, I'm gonna have you ask what will be the final question, and then Spencer, I'm gonna ask you about final thoughts. I would love to continue this for another half hour or hour, but we do have some business to take care of in addition to this. But thank you for sticking with us. Cindy, floor is yours.
Thank you. So I'm going to give the caveat that I am not an attorney, so forgive me for not quite following all of that sort of thing. You've explained well why it is not working for an attorney to take the case in Colorado, but my bigger concern is, so what if they do? Meaning, in Colorado, it doesn't seem that there's a fear of discrimination. There's not a fear of what's going to happen if people are discriminated against. So, for example, you can watch anyone with a service dog take an Uber, and you're going to watch at least one time they're going to have that call dropped, the driver's going to move on. You might get it the second time, more than likely it's going to be 3, because this is an ongoing pervasive issue. We have situations where people who are deaf, hard of hearing are in labor, delivering, and their option for interpreting is voice over internet, which is, a fixed TV somewhere. And if you're low vision, you can't even see the interpreter. The interpreter has a limited scope of vision, and that's their whole source of being able to communicate with their medical team. Or in the employment sector, for people who have vision loss, hearing loss, the first comeback is you didn't see that right, or you misunderstood, and their disability is essentially used against them. So my bigger concern is, what is the point of having intentional versus unintentional discrimination? How can we make the law work? I mean, if folks really worried about if somebody wins, and they are able to get a successful outcome for a discrimination suit, whether it's intentional or not, what if it was $10,000 and then maybe they face 10 times that if it was intentional? I just feel like we're not doing enough. And I'm wondering, from your perspective and your experience, what else can we do besides defining intentional, unintentional? And it seems like intentional doesn't really even happen here in Colorado. What else can we do to make our laws more robust and to make the system actually work?
So, Cindy, I think that's a fantastic question. And I think, part of the analysis and, part of the consideration for this committee is going to be striking a balancing interest between ensuring that this legislation has the teeth that it needs to provide a remedy for individuals who have that violation where they didn't get anywhere. And also understanding that, there's a business interest that is here to, ensure that we're not crippling small businesses who may not have even realized that their conduct was discriminatory. And I think, in an ideal world, my practice, it would be more educational than it would be, adversarial, right? And I think I've had a lot of cases that are educational. And I've had cases where, I've written a demand letter and, the company has responded and, they realized, oh my gosh, I didn't even realize that what I was doing was discriminatory, right? And I think I would hope that that is the case in most cases. Unfortunately, that's just not the reality. And I think to your point, ensuring that there is sufficient enough of a remedy. One thing that I will say is the CATA has for a long time allowed people to file charges of discrimination with the Colorado Civil Rights Division. And I think that is something that still needs to stay in place. Because the Colorado Civil Rights Division can still help individuals who potentially do not have an attorney enforce their rights under CATA. And I think that is something that is critical. That being said, it should not be mandatory to file under CATA or with the Colorado Civil Rights Division, because that is a huge impediment and it makes it almost impossible at times to see a remedy all the way through to resolution, because it creates a huge delay in pursuing cases. Cindy, my sense is that in terms of having a violation where it's not intentional, my sense is that there needs to be a reasonable cap, kind of going back to what I was talking about earlier, under Title VII, there are caps that already exist for unintentional discrimination. I think that balances the interest between ensuring that you get that individual compensation based on what a jury decides that it's going to be capped, to make sure that we're not going to put a small business out of business if it's a one-time incident. And then providing a second layer of damages for intentional discrimination. I think it's a tough balancing act that the committee has to engage in, but I think, having caps that are proclamated under Title VII, like, they're there for a reason, and they've been established for a reason. And I don't think we're looking at, if we're doing Title VII, you're not looking at a $10,000 damages cap. If it's a big business, Uber, you're looking at a cap of $300,000. That's not insignificant for a situation where there's a one-time violation for an individual who's maybe in labor and can't communicate. I mean, there's some real damages that are available for that. I think it's just, having to figure out how do we strike that balance to be fair to, maybe businesses that didn't even realize that what they were doing was discrimination. And I think that's really where it gets, and that again kind of goes back to Ian's question or Andrew's question about, like, why should we be allowing juries to assess these damages? Because every situation is different. Like, if it's a situation where, you have a pregnant woman in, a delivery room and she can't communicate because, nobody's using sign language with her and they're not accommodating her, that's pretty significant compared to maybe somebody who, got denied service once at a coffee shop. Like, that's certainly a violation and there's a remedy for that, but I don't think, having those two aren't the same. And that's something that a jury would have to be able to assess to figure out, okay, what is the proper level of damages in that circumstance.
So this is Cindy. Thank you. I think that, Andrew's point earlier about the fact that getting, a decision that something rises to the point of intentionality is quite difficult to impossible. And so I feel like a lot of intentional discrimination is happening because those who are doing this intentionally are doing so with impunity. And it's very concerning because in the hospital situation, because of money, they stuck with voice over internet is the accommodation we have to offer, period, end of statement. It's a sad situation. So I guess I'm still very unclear as to how intentionality helps. I do agree with you around small businesses. There used to be a decision about if a business is under X amount of, net profit that they earn a year, maybe they had, some sort of disclaimer. But bigger businesses, multi-million-dollar businesses, are taking advantage of that because 3,500 is a joke. That's like, okay, so we'll pay the 3,500 for 100 people. Big deal. It's no loss, and they're not worried. So I just feel like there's got to be more that we can do to make this effective.
Yeah, so I mean, I think again, to your point, I would not say 3,500 is an appropriate damages cap. And again, I don't think it should be a statutory fine because right now it's a statutory fine, not a damages cap. And I think those are two very different considerations. Personally, I think a damages cap is appropriate because what we're doing is we're not circumventing the providence of the jury to deliberate and determine an individual's damages. If it's a fine, we're sort of saying we don't care what the jury thinks. And so I think it should be a cap. I think utilizing, the Title VII damages cap is probably a good starting point. In terms of having intentional versus non-intentional, I do think that that serves some real value in terms of allowing individuals to recover more substantial damages for more egregious conduct. And, Andrew asked me, have I ever taken a case to trial and gotten a finding of intentional discrimination? The answer is no. And, the reality is the vast majority of cases don't go to trial. But if there is a situation, like where an individual, maybe the company was sued a month before, the discrimination and then did the exact same thing again, intentional discrimination may not be that hard to prove in that scenario. And the company arguably should be liable for a greater amount of damages in a scenario like that versus a one-time thing where they didn't provide accommodations. And so I think understanding intentional discrimination under the context of what it means in these cases is important because it's not intentional as in like what they did was malicious. It's intentional as in you knew what you were doing was discriminatory and you did it anyway. And I think having that mark in distinguishing the level of damages that are available, I do think that is important because I do think there should be a second level of damages for those companies that they know what they're doing. And there needs to be more exposure, for that company who says like, look, I've been sued time and time again. Like you're saying, like these big medical companies are doing it again without any care whatsoever. It's like, okay, well, if you keep doing this again, you'll be on the hook for uncapped compensatory damages, or you're going to be on the hook for punitive damages. And punitive damages is a very, very effective tool in a situation like that, where you have someone who is a repeat offender, because it's like, okay, now we're not trying to assess the damages that are needed to compensate this individual, because like, the emotional pain and suffering, it is what it is, irrespective of like how big the employer is or whether it had happened multiple times before. The punitive damages are like, you're doing this again. Now we need a jury to tell you to stop. So I think having different levels of damages like that does serve a very important purpose. I don't think that we should trivialize individual incidents. I think that there should be some sort of reasonable cap, but I think having that tiered approach just allows litigants in the court and the parties to properly fit that case into the right category. So I do think that is important. Maybe it's just a two-tiered system where you go from emotional pain and suffering directly to punitive damages. But I think my sense would be you have, some sort of damages cap, which would be, for all pain and suffering, compensatory damages, based on a Title VII type, scale, then have that damages cap go away, when it's intentional, and then have, a separate category of damages like malice, where someone's acting intentionally and with bad faith and having punitive damages available in that context. That's what I think. Obviously, reasonable minds can differ, but that's my 2 cents.
Thank you. I appreciate your feedback. Thank you.
Yeah.
Thank you. And I unfortunately am going to have to wrap this up because we've got to take care of some administrative stuff. Spencer, 2 minutes for closing thoughts. And so, as I said at the top, we're now going to be starting to sit down in June and develop ideas to float. And I'm looking at the interim report that we put together back in December. And just to remind folks, that included looking at definitions, emotional distress, damage caps and modernizing dollars, timelines for filing claims, standards for exhaustion, accountability measures. We talked about public accommodation laws and things like incorporating the 2010 DOJ standards for accessible design. We talked about the burdens for enforcement, timelines and costs to come into compliance. And we talked about process and rights for determining reasonable accommodations. And we did talk about the use of cannabis in medical situations. So, Spencer, we've got a whole set of things we're going to be digging into. I'm going to talk to the group about how we sequence this. What are your closing thoughts? And I'll call them closing, but I'll also ask if we can keep the door open to pick your brain as we go forward. But your thoughts as this group gets ready to find some bold recommendations that keep the ADA as the floor instead of the ceiling in Colorado.
Yeah, I mean, I think fundamentally, the most important thing for this group is to come up with a streamlined, or again, more maybe streamlined isn't the right word, but a more defined process whereby the damages that are contemplated by statutes like the ADA, Section 504 CATA are available. I think those damages should be capped under Title VII standards based on the size of the employer for unintentional violations. I think those caps should fall away if the violations are intentional. And I think the committee should authorize punitive damages in situations where companies are acting with malice or bad faith to deter that conduct from happening in the future. Fundamentally, I think the goal of the committee here needs to be to ensure that these types of cases have a viable way forward for private practitioners like myself. Because if there is not a statutory scheme in place that is going to allow me and other private practitioners to pursue cases like this, Coloradans, and again, this isn't just disability, minorities are going to fall by the wayside. They're not going to be protected the way they need to be under the Colorado Anti-Discrimination Act, because they're not going to be able to obtain representation. And then I also think with respect to, employment, the committee should take initiative here and make some decisions about medical cannabis and the use of medical cannabis as a medication to treat a disability. That is something that either the courts are going to decide or this committee is going to decide. And I think the committee should take initiative there and follow the framework that some other jurisdictions have already laid out and ensure that, individuals who come to use medical cannabis, are not then subject to discrimination in an employment context because, they specifically sought out something that Colorado has decided should be legal. I think those are my big points. You know, Barrick, obviously I'm happy to make myself available. If I can ever just like send you information, I can always just send you information as well. But I really did appreciate the opportunity to chat with you all. I think what you guys are doing is so important. And I know it's difficult work, but it's very much needed, right? So I really appreciate everything that you guys are doing. Thank you so much for your time.
Spencer, thank you. On behalf of what I know is this group's sincere thanks, the entire task force, and what will be some smarter work because of your time. So thank you. I wish I could continue it. We are down to like the last 12 minutes. I always would prefer to see the public engaged. This is one of those cases where I'm not bemoaning that because it meant that we got to continue this. I will also just thank all of the members for letting me pretty much blow up our agenda and let us use all of our time to talk with Spencer because it seemed like it was such an important conversation listening to everyone engage. What I had intended to use some time for was to go through all those topics that I rattled off in like 8 seconds and start a conversation about how we sequence those over the summer. I don't want to rush that. I want to maintain today's time on reflecting on what we just talked about. So in addition to Carrie's surveys about when we're going to get together, and I think this conversation probably highlighted why we need more time than was originally scheduled. I'm going to put that list of topics together into another little Google ranking thing, or you can just send it to me by email is fine. But we want to get your input based on everything we've talked about, based on what you're thinking right now, which topics we go deeply into in what sequence. I think there is some logic that things like definitions come at the end because we'll be adding to those. But in terms of sequencing, whether it's emotional distress, prescription cannabis, timelines and costs to come into compliance, we're going to want to pick your brains about how we sequence those across June, July, August, and September. But rather than using our time together, what I want to do is go around, and I'm sorry it's got to be a lightning round. So I'll ask for each member 60, 90 seconds. And Alana, I'm going to go to you first and then Cindy with just where your head is and your reflections coming out of today's conversation and what ideas it sparked in your mind for the work we need to do. So we'll go to Alana and then Cindy.
Thanks, Barrick. Yeah, this is Alana. I think my two biggest takeaways from today is one, I don't think I appreciated how useful it would be just to go back to kind of what the law used to be. So that's encouraging for me that even just going back to that is like, sounds like a really incredible start in improving all of this. And then also, I think I had underestimated how important it will be to look at medical cannabis and all of the impacts around that. So yeah, thank you. Today's discussion was really great.
Let's go to Cindy and then Tom Aker.
Yeah, this is Cindy. So I think that, one of the things that I feel like I've actually gathered some real insight into is at least a little bit about some direction that we can go in terms of, considering decisions that will not overwhelm small businesses, but perhaps add in more accountability in the law. So this is one of the most valuable discussions I think we've had so far, and I appreciate you giving more time for it.
Thank you, Cindy. Tom and then Lauren.
Thank you, Barrick. Tom Aker. In addition to what's already been said, I think looking at how we could define or better streamline I'm going to put it as damages that are sought, I think would be helpful so that people know what they might be facing if they do discriminate, rather be intentional or unintentional. And I think it should be a little bit different depending on the case.
Thanks, Tom. Lauren, Ian, Andrew, in that order.
Well, I join everybody in thanking you, Spencer. This has been a great conversation, and I have too many takeaways to narrow it down to just 2 points. But one of the things that resonated with me the most was our shared desire, I think, for a better education rather than having to take things to trial to have better outcomes for all Coloradans. That's something that obviously the business community, I think, would agree with. And so it's given me a lot to think about. Thank you very much for your time today.
Ian and Andrew, and everybody's being so quick that I can probably give you more like 120 seconds instead of the 90. Floor is yours, Ian, and then Andrew.
Thanks, Eric. Takeaways, we still got a lot of work to do. I think this is, this has been great watching this, the process we've been going through and ensuring that everybody is getting educated on these really important issues, but I feel like we still have a lot of work to do. The cannabis issue, I think my own personal view is it's fairly low hanging fruit in terms of how to address it compared to getting buy-in from the business community is going to be a different deal. I think the damages issues that everyone has flagged and that we've spoken about today are still going to give us a lot of work. Thinking through the things like what Spencer talked about today, the complexities of this area of the law for people who don't practice in it are immense. And so I leave with the takeaway that we've made great strides in terms of getting everybody educated, but I still feel like we have a lot of work to do going forward. And I guess something I want to flag is that post Cummings, the state of Illinois passed a law to essentially undo the problems that Cummings created. And I want to flag that because I feel like that's something that we all ought to look at as a potential opt-in for consideration in terms of how to address some of the Cummings-related issues, which only addresses one component of the damages issues we've been talking about. Still, I just throw that out there as an idea, and I'll send you that information offline. But yeah, I'm thrilled with the progress we've made, but man, we still got a long way to go, everybody.
I share those feelings, Ian. Yeah, if you'll send that to me, I'll make sure we circulate it. Andrew, and then I'll share what our next steps will be.
All right, thank you, Barrick. This is Andrew. Today's discussion has kind of helped me to re-examine some preconceived notions, so to speak, that I had coming into this. For instance, I initially was wholly opposed to the possibility of a damages cap because there never had existed one in these sorts of public entity and public accommodation claims. But I think Spencer's made a pretty persuasive argument for there being some sort of damages cap that's significantly higher than the statutory fine we have now, and that kind of tiered system. And I think that might make some sense. I'm gonna have to give it a little bit more thought, but just re-examining some of my original thoughts. With respect to a statutory fine, I think I still do see some benefits to having a statutory fine, but I think, frankly, it's not a this or that. It could be both. You could allow for a statutory fine to exist if someone doesn't want to go through the headache of going through an entire jury trial just to get some small amount of damages. You could simply seek a statutory fine. But again, Spencer made some good points as far as a jury should be the one to determine these more significant damages amounts, if nothing else. Kind of final last thought, I guess, is, we've spent a lot of time talking about damages, whether emotional distress damages should be available in the first place, how we do that. Something else, and I'm not sure if we're even able to address this, but something else I think we all agree on is that one of the purposes of the law is to essentially eliminate discrimination, to prevent the discrimination from happening in the first place. One of the ways that we do that under the law is through injunctive relief. And obtaining injunctive relief is pretty difficult due to some court-created standards. You've essentially got to show that you're going to suffer the same sort of discrimination again in the future by that same entity in order for a court to order them to fix the problem, essentially. Again, I'm not sure if we're going to be able to do so, but I would love to put some brain power behind thinking about ways to potentially get around that and get some relief for people, even if, and I'm not talking monetary relief, I'm talking fixing the problem sorts of relief. Even if it doesn't rise to the level that courts want us to prove to get that court order to fix the problem in the first place. Otherwise, all we really are left with is damages and attorney's fees, and that it gets us a little further toward fixing the problem. But if we can actually get to the root of that, that would be spectacular.
Thank you, Andrew. And I think Andrew and Ian, I think everyone highlights that the more we peel this back, the more complicated we realize it is. And I think, as a few people have alluded to today and in past meetings, we need to get at the core charges in front of us, which do include some things like the emotional damages. We probably have a moral imperative to get at some of that low-hanging fruit. I think there is a reality that you all are probably going to identify 30 issues in need of solving, and we may have solutions for 10 of them. So part of your recommendations may end up being the work that needs to continue, with time being of the essence on that. What we're going to do is a few things. We're going to follow up to nudge you on when we can get together for an additional meeting, whether an in-person deep dive session is practical and is of interest. I don't want people to feel pressure. It's just something that's been floated, so we're going to ask about it. We are also going to recirculate that report that came out of the conversations going into December that identified some of the issues. We'll bundle all of that together and follow up with everyone with the questions of what we want to prioritize in the sequencing of conversations. And when I say prioritize, that doesn't mean we're going to leave some things off, but we need your input on whether there are issues that you think it makes rational sense to dig into first, because they may inform some of our subsequent conversations. So between now and probably the end of the day Wednesday, Terry and I will follow up with all of you with those questions of adding additional dates, of the possibility of an extended deep dive time, whether in person or not, with the sequencing questions. And we'll continue to welcome all of your input as we try to sort through which issues we tackle. Andrew and Ian and everyone, I agree with all of your sentiments. We got a lot of work to do. I think it's been important that we spent these first 5 months getting everyone leveled up, hearing from a lot of different perspectives, from Spencer, from CCRD, from others with lived experience, which is going to be a big part of our work this summer. But now it's time to roll up the sleeves and dig into each one of these and say, okay, we've had some big picture, academically interesting conversations. Now it's time to put these ideas on the table. And as I said at the top of the call, to share those out to people with lived experience, with professional experience navigating these issues, and with a lot of different perspectives. So I want to thank Spencer, thank you again for your time and the thought-provoking conversation. Members, I will continue to always be grateful for your generous contribution of time and expertise. We will follow up with all of you with our ask for more of that generous time, and for your input on how we sequence these topics to start putting ideas on the table that we can share out. So with that, thank you all. Have a wonderful week, and we'll be in touch by email in the next couple of days.
Bye, everyone. Thank you.